Somewhere on the western edge of America, perched on the shores of San Francisco Bay, sits a prison that has held more condemned men than any other facility in the United States. A place where the years stretch like shadows, where the law's final verdict echoes in stone corridors. This is San Quentin. And today, we go inside the most scrutinized, most controversial death row in American history. Stay with us, because what you're about to discover will challenge everything you think you know about justice, reform, and the price of punishment. Bell, if stories like this fascinate you, hit that subscribe button right now. You're watching Behind the Wall Stories, where the truth is always more powerful than fiction. Long before San Quentin became synonymous with death row, it was simply a desperate solution to a growing problem. In the years following the California gold rush, the state's population exploded almost overnight. Towns swelled, lawlessness spread through mining camps and river ports, and California's infant legal system was barely able to keep pace. The need for a permanent state prison was urgent, and authorities moved quickly, perhaps too quickly, to find a solution. In 1852, California officially established its first state prison, not in a grand purpose-built facility, but aboard a decommissioned ship called the Wobbin, anchored in San Francisco Bay. Prisoners were kept in cramped, unsanitary quarters below deck, managed by a private contractor named James Estelle, who had won the right to run the prison through a lease agreement with the state. The arrangement was deeply flawed from the beginning, rife with concerns about prisoner treatment and the motivations of those profiting from incarceration. Within just a year, state officials recognized that a land-based facility was essential. In 1853, construction began on what would become San Quentin State Prison, situated on a 20-acre land grant on a peninsula in Marin County, overlooking the bay. The location was chosen in part for its natural isolation, water on three sides, and in part because the land had been acquired controversially from a Mexican land grant. The prison's physical foundation, from its very first stones, was laid on ground with a complicated history. The early decades of San Quentin were marked by primitive conditions. The original cell block, known as the Stones, was constructed largely by the prisoners themselves, a common practice at the time and one that underscored the era's utilitarian view of incarceration. There was no uniform rehabilitation philosophy. Work, punishment, and containment were the guiding principles. Prisoners quarried rock, built roads, and labored under the supervision of contractors who retained financial interests in their productivity. By the mid-1800s, San Quentin had already drawn public criticism. Investigative reports from journalists and state inspectors documented overcrowding, disease outbreaks, and inconsistent treatment of inmates. California's legislature debated reform repeatedly, but institutional change came slowly. The prison expanded as the state expanded, absorbing more prisoners as California's population grew through the latter half of the 19th century. By the turn of the 20th century, San Quentin had transformed from a makeshift solution into an established institution, one that reflected the tensions running through American society itself. The tension between punishment and rehabilitation, between public safety and human dignity. It had evolved from a converted ship to a sprawling complex with thousands of beds, dozens of programs, and an increasingly complicated legacy. What it did not yet have, officially, was a death row. That would come, and when it did, it would change San Quentin's identity forever. For decades, San Quentin operated as California's primary prison, without a formal, designated space for condemned inmates. Executions occurred, but the machinery of state-sanctioned death was inconsistent, decentralized, and, by the standards of the time, poorly regulated. That would change dramatically in the early 20th century, when California made a series of legal and architectural decisions that would define San Quentin's identity for the next 100 years. California's first method of execution was hanging. From statehood in 1850 through the early 1890s, Executions were carried out at the county level, meaning condemned prisoners were hanged in the counties where their crimes had been committed. This decentralized system created enormous inconsistency. Different counties had different protocols, different levels of public access, and wildly different standards of what constituted a humane execution. Public hangings drew crowds in some jurisdictions. In others, executions were conducted in near total secrecy. In 1891, the California legislature passed a landmark reform. All executions in the state would henceforth be centralized at one of two state prisons, San Quentin for inmates from Northern California and Folsom Prison for those from the South. The gallows at San Quentin were formalized. A dedicated execution chamber was constructed within the prison walls. For the first time in California history, condemned inmates had a specific, permanent destination, and San Quentin had a specific, permanent function that went beyond ordinary incarceration. The first execution under this new centralized system took place at San Quentin in 1893. Jose Gabriel, convicted of murder in Fresno County, was hanged within the prison walls. His execution marked the formal beginning of San Quentin's role as California's primary execution facility, a role it held with only brief interruptions for over a century. Throughout the late 1890s and early 1900s, the number of condemned inmates at San Quentin grew steadily. California's population was expanding rapidly, its cities industrializing, and its criminal justice system hardening in response to rising urban crime rates. The gallows at San Quentin became an increasingly active instrument of state policy. Then came a pivotal shift. In 1937, California became one of the first states in the American West to adopt lethal gas as its official method of execution, replacing hanging. A gas chamber, formerly called the lethal gas chamber in state documentation, was constructed at San Quentin. The octagonal steel chamber, painted sage green, will become one of the most recognized and debated structures in American penal history. It was designed to be more humane than hanging, its advocates argued. Critics disagreed, and the debate over its use would intensify with every passing decade. The gas chamber's first use at San Quentin came in December 1938, when Robert Lee Cannon and Albert Kessel became the first two inmates executed by lethal gas in California. Their executions drew national press attention and marked the beginning of a new, more bureaucratic, and more medicalized era of capital punishment in the American West. Alongside the gas chamber came the formal designation of a condemned unit, what the public and press increasingly began calling death row. Condemned inmates were separated from the general prison population, housed in a dedicated section of the prison, and placed under a distinct set of regulations. Their world shrank to a cell a yard in the slow, grinding way to a legal process that could take years, sometimes decades, to reach its conclusion. San Quentin's death row was not yet the largest in the nation, but it was growing, and the legal, moral, and political battles that would eventually make it the most scrutinized condemned unit in American history were already beginning to gather, quiet and inevitable, like weather forming over the bay. Every institution is ultimately defined not by its walls, but by the human stories contained within them. San Quentin's death row, over the course of more than a century, became the final address of some of the most documented, most debated, and most legally consequential condemned cases in American criminal justice history. These were not abstractions. They were individuals, each with a case file, a legal history, and a story that forced America to confront uncomfortable questions about justice, race, mental illness, and the limits of state power. Among the earliest cases to draw sustained national attention was that of Carol Chessman. Convicted in 1948 on 17 counts, including kidnapping and robbery under California's so-called Little Lindbergh Law, Chessman was sentenced to death and sent to San Quentin's condemned unit. What followed was one of the most extraordinary legal battles in American penal history. chess man, representing himself for significant portions of his appeals process, filed petition after petition, authored 4 published books from his death row cell, including the best-selling memoir Cell 2455 Death Row, and became an internationally recognized symbol of the debate over capital punishment. His case attracted attention from world leaders, celebrities, and legal scholars across Europe and the United States. He was executed in May 1960 after surviving 8 separate execution dates over 12 years. His case accelerated the national conversation about capital punishment in ways few individual cases ever have. The 1960s brought further seismic legal disruption to San Quentin's death row. In 1972, the United States Supreme Court issued its landmark ruling in Furman v. Georgia, effectively halting all executions in the United States by ruling that the death penalty as an administered constituted cruel and unusual punishment under the Eighth Amendment. Every inmate on death row across America, including all those at San Quentin, had their sentences commuted to life imprisonment. Death row, as a physical and legal designation, was temporarily dissolved. It did not remain dissolved for long. In 1976, the Supreme Court ruled in Gregg v. Georgia that capital punishment was constitutionally permissible under revised sentencing guidelines. California subsequently reinstated the death penalty through a voter-approved ballot measure. San Quentin's condemned unit was reconstituted. Inmates began arriving again. The legal machinery of death row resumed its slow, grinding operation. The cases that accumulated on San Quentin's reconstituted death row to the 1980s and 1990s were among the most serious and widely reported in California history. Robert Alton Harris, convicted of the 1978 murders of 2 teenage boys in San Diego County, became the first person executed in California following the death penalty's reinstatement. Put to death in San Quentin's gas chamber in April 1992. His execution was itself surrounded by extraordinary legal drama. The United States Ninth Circuit Court of Appeals issued 4 separate last-minute stays of execution within hours of the scheduled time. The Supreme Court ultimately intervened to allow the execution proceed, issuing an unprecedented order barring the Ninth Circuit from issuing further stays in the case. Harris's execution reignited the national debate about lethal gas as a method of execution. A federal judge subsequently ruled that execution by lethal gas constituted cruel and unusual punishment. California transitioned to lethal injection, installing a new execution chamber at San Quentin. By the late 1990s and early 2000s, San Quentin's death row had grown into one of the largest condemned populations in the United States. A sprawling, legally complex community of inmates whose cases collectively represented hundreds of thousands of pages of court documents, decades of appeals, and an ongoing, unresolved national argument about whether the death penalty could ever be administered with true justice and consistency. The faces changed, the arguments deepened, and San Quentin remained, watching, waiting, holding them all. To understand San Quentin's death row is to understand something that defies easy categorization, something that exists in the space between punishment and prolonged psychological endurance. For the men housed in the condemned unit, the experience of incarceration is fundamentally different from any other form of imprisonment in the American system. It is not defined primarily by violence or chaos, though both have existed within its walls. It is defined, above all else, by waiting. By the early 2000s, San Quentin held the largest single death row population of any prison in the United States. At its peak, more than 740 men resided in the condemned unit, a number that dwarfed the death row populations of Texas, Florida, and every other state in the nation. The sheer scale of the population created a community unlike any other in the American penal system, a permanent, self-contained world operating under its own rhythms, tensions, and, remarkably, its own forms of structure and meaning. The physical layout of San Quentin's condemned unit evolved considerably over the decades. By the 2000s, condemned inmates were primarily housed in the East Block and the Newer Adjustment Center, two distinct environments with different security classifications and conditions. The East Block, a massive 5-tier Victorian-era cell block built in the 1920s, housed a majority of condemned inmates in individual cells approximately 4 feet wide and 10 feet deep. Each man spent the vast majority of each day within these dimensions. Conditions were stark: a bunk, a small shelf, a toilet and sink combination unit, and whatever personal items have been approved through the prison's property regulations. Daily life on death row operated on a rigid institutional schedule. Wake-up calls came early. Meals were delivered to cells on trays. Exercise, referred to officially as yard time, was provided in small, enclosed concrete exercise areas for limited hours each week. Access to programming, education, and religious services existed, but was restricted compared to the general prison population. Condemned inmates were largely separated from the broader prison community, their movements tightly controlled and individually supervised. What documented accounts, from correctional officers, legal advocates, journalists, and court records, consistently reveal is a population characterized by extraordinary diversity of background, age, and circumstance. San Quentin's death row at any given point included men who had been incarcerated for over 30 years, men whose cases remain in active appeals, men who had been exonerated and removed from death row, and men who had voluntarily waived their appeals and requested execution. Mental health emerged over the decades as one of the most critically documented concerns on San Quentin's death row. Multiple independent studies, legal findings, and advocacy reports documented high rates of severe mental illness among the condemned population. The combination of indefinite confinement, the chronic psychological stress of a death sentence, and limited access to consistent mental health treatment created conditions that courts and mental health professionals repeatedly flagged as serious welfare concerns. Legal challenges based on these conditions resulted in multiple court orders requiring improvements to mental health provision within the condemned unit. Educational and creative programs also found a place within San Quentin's walls. The prison's broader educational programs, including college-level courses provided through partnerships with local universities, touched portions of the death row population. Some condemned inmates produced artwork, legal scholarship, and written work of documented quality during their decades of incarceration. The condemned unit at San Quentin was never simply a place of waiting for death. It became, over generations, a complex human environment, one that reflected every contradiction embedded in America's long, unresolved relationship with capital punishment. The men inside were not abstractions. They were the human face of a policy debate that has never been settled. And outside the walls, that debate was about to reach a turning point. Every institution eventually faces a moment of reckoning, a point at which the weight of its history, the pressure of its present, and the demands of its future converge into something that cannot be ignored. For San Quentin State Prison, that reckoning arrived not in a single dramatic moment, but through a long, accumulating series of legal decisions, political shifts, public debates, and documented human consequences that would fundamentally alter the prison's identity in the 21st century. The question of California's death penalty had been contested in the courts, in the legislature, and at the ballot box for decades. But the early 2000s brought a new intensity to that debate. DNA exoneration cases across the United States, many involving men who had served years on death rows nationwide, cast serious doubt on the reliability of capital convictions. California was not immune. Several inmates were removed from San Quentin's condemned unit, following successful appeals, new evidence reviews, and in some cases prosecutorial misconduct findings. Each such case deepened public unease about the system's accuracy and fairness. In 2006, a federal court ruling in Morales v. Hickman found serious constitutional concerns with California's lethal injection protocol, specifically the risk of pain and suffering during the procedure. The ruling halted executions in California and triggered years of legal and administrative proceedings as the state attempted to revise its execution protocols to meet constitutional standards. Despite multiple revision attempts, California's execution chamber at San Quentin remained inactive. The last execution carried out at the prison took place in January 2006. The lethal injection of Clarence Ray Allen, age 76, who had been on death row for over 20 years. Following that execution, California entered what became an extended de facto moratorium on capital punishment. In 2019, Governor Gavin Newsom formalized this position, issuing an executive order placing an official moratorium on all executions in California for the duration of his administration. He simultaneously ordered the dismantling of the execution chamber at San Quentin. The Sage Green gas chamber and the lethal injection facility were both decommissioned. The physical infrastructure of execution at San Quentin was systematically removed. Then came a decision that reverberated across the entire American correction system. In 2023, California announced a sweeping transformation plan for San Quentin State Prison itself. Rather than continuing its function as a maximum security facility housing condemned inmates and general population prisoners, San Quentin would be reimagined and redeveloped as a rehabilitative campus, a model facility focused on education, vocational training, mental health treatment, and reintegration preparation. The announcement drew international attention. Experts in criminal justice reform from Europe, particularly from Scandinavian countries whose rehabilitative prison models had influenced California's reform advocates, were consulted in the planning process. The transformation plan raised profound questions that had no simple answers. What happens to the more than 600 men still formally designated as condemned under California law? Men whose death sentences remain legally in place even as the state has ceased executing anyone. What does it mean to maintain a death row when executions have stopped indefinitely? What obligations does the state carry toward men who have spent 20, 30, or even 40 years in a condemned unit? San Quentin's history offers no clean conclusions. It offers instead a mirror, one held up to reflect America's evolving, unresolved, deeply contested understanding of justice, punishment, and human dignity. From a converted prison ship in 1852 to a proposed rehabilitative campus in 2023, the institution has survived, adapted, and transformed across 17 decades of American history. The condemned unit that once held over 740 men, the largest death row in the United States, stands today as a monument to a national argument that has never been settled. The bay outside its walls still glitters. The walls themselves still stand, and the questions they contain are still, in every meaningful sense, alive. San Quentin endures, and so does the reckoning. San Quentin has stood on the edge of that bay for over 170 years. It has witnessed executions and exonerations, Supreme Court rulings and gubernatorial orders, decades of legal battles and generations of condemned men waiting for answers that came slowly, sometimes too slowly, sometimes not at all. What it leaves us with is not a simple verdict. It leaves us with a question, one that every society that claims to value justice must eventually answer. What do we do with the worst among us? And how we answer that question says everything about who we are. That is why stories like this one must be told. Accurately, completely, without fear. If this documentary gave you something to think about, something real, something verified, something that challenged the way you see justice in America, then do one thing right now. Hit that subscribe button. Join the Behind the Walls Stories community, where every other day, we go inside the institutions, the cases, and the human stories that shape the criminal justice system you live under today. Drop a comment below. Tell us, should San Quentin's transformation into a rehabilitation campus give us hope? Or is it too little, too late? We want to know what you think. Share this documentary with someone who needs to see it. One share is one more person who knows the truth. And remember, the walls have stories. We make sure the world hears them. Behind the wall stories. Every other day. Always the truth.